Hey, thanks for coming.
Oh,
I guess we're recording now. So I wanted to go over some of the assembly bills that were effective this year, and it does affect us. Some not as much as others, but I'll go through the ones that I think are most relevant. Assembly Bill 246 enacts the Social Security Tenant Protection Act of 2025 to provide residential tenants an affirmative defense in an unlawful detainer proceeding for the non-payment of rent if they experience a loss of income during a Social Security payment interruption that resulted from the action or inaction of the federal government. So that sunsets January 20th, 2029. So for recipients of Social Security, if they aren't getting the money for whatever reason, they're entitled to a 1 year affirmative defense against an unlawful detainer action. I haven't been aware of it, and even maybe because Social Security might be theoretically going broke at some point in time, it very well may impact people. Assembly Bill 414, and this is really critical, requires a landlord or their successor, so somebody who buys a landlord's property, who receives a security deposit or rental payment from a residential tenant by electronic transfer, to return the security deposit by electronic transfer, unless the landlord or landlord's successor and tenant agree in writing to another method of returning the security deposit. Landlords or their successors have to notice tenants of their right to receive security deposit electronically within a reasonable period of time after notification of either party's intention to terminate the tenancy. This bill provides that upon mutual agreement between the landlord and tenant, the landlord may send to the tenant by email the required itemized statements, so the detail of any deductions, which specifies repairs or cleanings that will be deducted from security deposit. This bill additionally provides a method by which a security deposit and the itemized statement shall be returned to multiple departing tenants. So if the landlord once again received the initial funds electronically, you have an obligation to return the funds electronically, unless you have something in writing that's going to, in which both parties agree to another form, for example, a check. So the core changes, mandatory electronic funds. Under existing law, landlords and tenants could agree to an electronic refund only after a notice of termination had been given and the default remained a paper check or personal delivery. Assembly Bill 414 instead provides that if the tenant pay the security deposit or rent electronically, the landlord must return any remaining security deposit electronically unless the parties have agreed in writing to a different method. So practically, this means that property managers who accepted ACH, debit, credit card, or app-based payments for rent or deposits will generally be required to push refunds back through an electronic transfer, for example, an ACH transfer, rather than cutting checks, absent a written designation of another method. This bill also requires landlords to notify tenants in writing of their right to receive the security deposit electronically, so tenants are aware of this option. If there's a termination of tenancy coming up, you have an obligation as the landlord or property manager to notify the tenants that if they had submitted the money electronically, and it doesn't matter if it was 10 years ago that they submitted the money electronically, you now have an obligation to return electronically. So if multiple tenants exist and they all deposited the security deposit electronically, must each tenant receive the funds they individually deposited electronically? And students, that might be a very good example. So now the default for AB 414 for multiple tenants is a single refund payable to all adult tenants by check or single electronic transfer, not separate refunding matching what each person originally paid, unless everyone agrees in writing to a different allocation. So once again, for a unit with multiple adult tenants on the same lease, AB 414 requires that the remaining security deposit be returned as one payment made payable to all adult tenants named on the rental or lease agreement at the same time tenancy ends. So typically in the past, if there are multiple people on the lease, the landlord's obligation was to write the check and name Carlos, Mike, so on and so forth on that one check. Now, how do you do that when it's an electronic transfer? It just isn't possible. So there's going to have to be an agreement in regards to whose account you're going to be transferring that into. However, if each person they don't trust each other, then all parties to the lease must agree in writing with the landlord that whatever dollar amount they believe they're entitled to must be stipulated in that separate agreement.
Are they going to modify the lease agreement to?
That's a good question. That I wouldn't be surprised. I looked, and I think the last change was June 25th in a lease agreement. So in terms of how we accommodate multiple tenants, I don't think it's necessarily going to be easy. I think for the most part, most of the tenants are probably family members. So it comes from one source. So that does simplify it. But if we do have multiple tenants, then it's going to complicate the return of those monies. Let's see, Assembly Bill 445 requires the seller of single-family or residential real property who has knowledge of any residue from or any history of smoking tobacco or nicotine products on the property to disclose that knowledge to the buyer. Now, this does not include pot, so it says. Yeah, interesting, huh? This bill also requires the Department of Toxic Substances Control, in collaboration with the Center for Tobacco and the Environment at San Diego State University, to update the Homeowner's Guide to Environmental Hazards with information regarding third-hand smoke. So we're going to receive an amended environmental hazards report at some point in time. It's going to talk about the dangers of third-hand smoke. And then Assembly Bill 628. For rental agreements entered into, amended, or extended on or after January 1st, 2026, requires the following to be included in a residential dwelling unit for the unit to be considered tenantable. 1, a stove that is maintained in good working order and capable of safely generating heat for cooking purposes, and a refrigerator that is maintained in good working order and capable of safely storing food. So a stove that is subject to a recall by the manufacturer of a public entity will not be considered capable of safely generating heat for cooking purposes. Likewise, a refrigerator that is subject to a recall by the manufacturer or public entity will not be considered capable of safely storing food. A landlord is required to repair or replace a stove or refrigerator that is subject to recall within 30 days of receiving notice of the recall. And if you notice, it said a lease that is renewed or extended. So that now applies if there's no refrigerator provided. Stoves, I think it's pretty common, as a matter of fact, that they're included. The requirement to provide a stove and a refrigerator is not applied to permanent supportive housing units, single room occupancy units, residential hotels, and dwelling units within a facility that offers shared kitchen spaces for residents. Tenants are allowed to furnish their own refrigerator, and this language is already in the lease agreement that we use that's provided through zip forms. So tenants are allowed to furnish their own refrigerator if mutually agreed by the tenant and landlord and the following conditions are met. The lease contains a clause noting the requirement for a landlord to provide a refrigerator. By checking a box in the lease, the tenant acknowledges that they have asked to bring their own refrigerator and are responsible for keeping it in working order. The lease provides that the tenant may, within 30 days written notice, inform the landlord that they no longer wish to keep their own refrigerator in the unit, and that at the end of the 30-day notice period, the landlord will install a refrigerator in good working order in the unit, and a landlord cannot condition a tenancy upon the tenant providing a refrigerator. So if they decided they want their own refrigerator, change their minds, the landlord has an obligation to provide a refrigerator.
30 days.
30 days, yes, yeah. And this is very important, Assembly Bill 723, requires a real estate licensee or person acting on their behalf who includes a digitally altered image as defined in an advertisement or promotional material for the sale of real property to also include a statement in the advertisement or promotional material that discloses that the image was digitally altered. They must also provide a link to a publicly accessible website, URL, or QR code that includes and clearly identifies the original unaltered image. The disclosure statement must be reasonably conspicuous and located on or adjacent to the image, and must include language indicating that the unaltered image can be accessed on the linked internet website, URL, or QR code. So I see many agents giving notification. Now, are they providing the link or QR code for the original photo? That's a different issue. This isn't just necessarily a violation of the rules and regulations. This is a violation of California law.
Is this just for the MLS or for any advertising?
Any advertising by a licensee.
I
So-
was with an agent recently and he got fined $2,500 because he didn't put that his image was altered,
Yeah,
and that was just like that.
yeah,
So on the MLS underneath the picture, you have to put, this is not.
that it's been altered.
So
And then
if
you
I do
need,
virtual staging, I can put, this is virtually staged.
yes, and then you need to provide the actual original picture also with it in some capacity.
I was wondering why, because they have a vacant room.
And then one stage.
And that
Yeah.
kind of, to me, defeats the purpose of.
Digitally staging it, yes.
Yeah, oh, I was wondering about that, okay.
Yeah, that's why they do that.
They're altering these pictures way too hard.
Yeah.
Like the interiors of some of these houses are nothing like what they are in photos. It's crazy.
And you have to wonder if buyers are probably, if they find honesty the best policy when they walk into these homes and they look at the pictures, as you're pointing out, and they're far different than what they're actually physically seeing. Do they walk out because they're disgusted, thinking, you know, you've actually taken away any trust that I had in you, right? Because you modified these so dramatically.
We're kind of the same right now.
Oh my God.
They're walking in saying, they're walking in saying, you got me.
And then if the advertisement or promotional material is posted on an internet website over which a licensee or a person acting on their behalf has control, they are required to additionally include in the posting the unaltered version of the image from which the digitally altered image was created. The licensee or a person acting on their behalf may comply with this requirement by including a link to a publicly accessible internet website that includes and clearly identifies the original unaltered image and a statement indicating that the unaltered images can be accessed on the link internet website, URL, or QR code. So it's suggesting anywhere you post altered images, you must give notification they have been altered, and you need to provide a link or access to the original photo.
And would that be on a private remarks or what would you put this link?
Well, that's a good question. You know, if you're on the MLS, you can actually put a description on the MLS, right? That's simple. But if you're just posting something on Facebook, you know exactly how you're going to implement that language. That's a good question. Now on the MLS, I don't know what we do in terms of providing the original photo. Can you put a QR code on a photo that's been digitally altered? And if somebody clicks on that QR code, would it take them to the original photo?
On the MLS, I don't think you can add any QR codes or anything like that to the photos, but what they recommended originally was to upload the picture of the original photo and the staged photo, virtually staged photo, but writing underneath that the photo is virtually staged, so you see both of them.
I see.
But if they're asking for a link, where are you supposed to put this link?
Well, that's just it. If you don't have a link and if you have the altered photo and then the next photo is the original,
Then you don't need.
I would think that that would be sufficient. Yeah, so that's a big issue for all of us, as a matter of fact.
Yeah, for flyers too. People are putting out the best looking pictures,
Yeah,
and the best looking pictures are the altered ones.
and maybe on a flyer, you can actually implement
QR code.
a QR code that it takes them to the original photo.
Cleaning it up and changing, they're completely different things. Like a couple of the houses we saw in LA, the interiors were just decrepit compared, and it was like this newly remodeled photo. in MLS. I was like,
I keep telling him, welcome to real estate.
Yeah, is it worth it? I don't know. The salespeople in here know better than me. Is it worth it to do that? At one time, maybe it gets people to the house, but then they're disappointed when they find that what they're looking at is not a fair representation of the property.
What if the agent is using a digitally altered photo of themselves? Like in real estate, yeah, that's a thing, right? So like, is there a violation for that?
Wow.
That was them 20 years ago.
I'd say another star. Yeah, you don't want to click on that link.
They walk in, they're like, "Are you're the listing agent?"
And this is a small note, but people may ask you this. Senate Bill 770 deletes a requirement that a homeowner's insurance policy name the homeowners association as an additional insured party when a homeowner installs an electric vehicle charging station in a common area of a common interest development. Even, typically, if you're required to name somebody as an additional insured or additional interest, there's usually no additional charge. But now an HOA cannot force you to do that if you're installing a charging station on common area property. And then artificial intelligence in California, real estate opportunities, risk, and compliance considerations for licensees. This affects all of us. So, common usage of AI in real estate. I'm just going to go over a few of these. AI tools are diverse, but current use generally falls into the following categories in real estate practice. Although some of these may conflict with existing law and regulations, marketing and advertising, drafting listing descriptions, generate social media content, and create promotional material, including AI-enhanced imagery, lead generation and customer interaction, using AI-powered chatbots and automated lead scoring to help manage inquiries and prioritize follow-up. And there's a reason I'm going through these. Property valuation and market analytics, synthesizing market data for automated valuation models and dynamic pricing tools, supporting transactions and document review, summarizing documents, tracking deadlines, and identifying potential errors or noncompliance in the Orange County Register on Sunday. There are 2 agents that are supposedly developing an AI model that will take the place of a TC. So that's going to be very interesting to see how that works. Mortgage servicing using AI tools for predictive analytics, including analyzing borrower behavior, historical data, and macroeconomic factors to reduce defaults. So the legal and regulatory considerations, broker supervision, me, and this is you, licensee responsibility. The use of AI in a real estate practice does not alter 3 fundamental principles. First, only persons or corporations licensed by the Department of Real Estate are permitted to perform real estate license activities. Second, brokers must reasonably supervise the activities taking place under their license. Finally, brokers and their affiliated licensees owe fiduciary duties to their client. California law under Business and Professions Codes 10177, 10159, and Regulations Section 2725 places responsibilities on brokers to supervise the activities of their affiliated licensees and the operations of the brokerage. Plus, Business and Professions Code Section 1131 outlines the activities that require a real estate license, and brokers must be aware of the activities any unlicensed assistants take in carrying out the operations of a brokerage. A broker's supervisory obligation extends to the tools used to conduct licensed or unlicensed activities, including AI-powered software. If an AI tool generates inaccurate information, misleading advertising, or improper communications with consumers, responsibility under current law rests with the licensee and a responsible broker, not the technology provider. Now, Mike, you had one time a client who has developed technology that would begin making phone calls, right?
Yeah, he let me listen to it, and
Yeah.
it's pretty impressive, actually.
Yeah, and that's probably a violation because it's not licensed. If they're performing licensed activity possibly without a license.
His stuff, I think, was for medical.
But they can use it for
but I
anything,
was trying to ask him to use it for
real estate.
real estate. You know, like I did a few years ago where you have a dialer, a computer dial the
Mhm.
numbers and leave a message.
Yeah,
It was like that, but when somebody picks up now, the AI assistant will actually talk to them. It's fascinating.
it is.
And she listens, she hears, and she answers what the person asks, which amazed me.
It's probably answering real estate related questions.
So you're saying that the AI person has to be, whoever has that AI has to be licensed?
No, that's saying that only corporations and individuals can be licensed to perform real estate related activity. So the system itself, it cannot be licensed, and you would be held responsible for the implementation of that software. Actually, you and I. It's very interesting, yeah. Because if it's answering any type of real estate related questions, and you can't license.
So if I hired that guy to make calls for me, that would be legal or illegal?
Well, it depends. We'd have to monitor exactly what he's saying. Just like unlicensed assistants, there are guidelines for unlicensed assistants, and we have them sign a document giving them the guidelines of what they can actually say to somebody. But even an open house, an unlicensed assistant can be present, and they can hand out flyers, but they can't answer any of the questions associated with that property itself, because that would be considered a violation.
Even transaction coordinators, right? There's certain things that they can't do.
Absolutely. Yeah, if it's better that they have a license, actually. There's no question about that, because I think it's so easy to cross over
Yeah.
and answer questions that are real estate related. And then unauthorized practice of law and reliance on AI generated legal content. Some AI tools offer to generate contract language, explain legal rights, or interpret disclosure documents. Licensees must exercise caution when using such tools. A licensee who provides legal advice or legal interpretations beyond the scope of what their real estate license permits may constitute the unauthorized practice of law, which is a crime under Business and Professions Code, sections 61, 25, and 26. So AI generated explanations or document summaries should not replace attorney advice, statutory disclosures, or a licensee's obligation to recommend that consumers seek legal counsel when appropriate. Now, I have had one case in which an attorney on behalf of Keller Williams contacted me and said I was practicing law by what I was writing. Right? It wasn't using AI, but it didn't matter. And she was threatening to report me, as a matter of fact, to try to get me away. And it's probably true. I think we probably sometimes engage in that without really intentionally to do that, trying to help our clients. But I think with AI, it makes it that much easier in regards to interpretation of things and maybe what we're sending out. So we just need to be cognizant of that.
Rich, back to the software stuff. I think it should be the software's manufacturer's responsibility because they sold it to general publics. We don't have the background of the code, whatever created. So the responsibility should go back to the software company for them to validate their output will not violate the regulation.
Well, I don't think California law looks at it that way. I think they look at the person who's implementing the usage of whatever the product is, because there's probably other cases in which usage of that technology is perfectly acceptable. Licensing is not required. So that's just it. Only a licensee or a corporation that's properly licensed can engage in real estate related activity. So that's why they're telling us some of these AI tools that could be used in that capacity cannot be licensed.
Yeah, but even we are licensed, but we don't know the background of the software, right?
What's that have to do with it?
Generate something may violate the law, but as a user, we don't know. Okay.
But
anyway,
you know that
that's
you know that you can't use it and you're using it anyway. So that alone is a violation.
We don't know. We don't know whether it's not.
Well, they're saying not to use it.
Okay, but there are so many cases. If you use 100 cases, maybe one violates, you
Yeah.
Just don't know.
That's a risk you take.
Yeah, it's risky.
They're saying the AI is gonna replace everything. They're not gonna replace us because then
Yeah.
we can't be licensed.
Yeah, they can't be licensed. So we can thank the state of California for that. There's one thing they're doing right.
Not licensed.
They're not licensed, exactly. And remember, even simple things, LLCs, if someone claims to you and they write a contract and it's an LLC cannot be licensed in the state of California. Only a corporation or an individual can be licensed. So we do have a few videos that we'd like to play that were sent to us by Orange County Realtors, and I think they're very helpful. So a couple things we just want to talk about: registered listings, what to do once you have a registered listing. We'll just go through the list as a matter of fact. Yeah.
You on entering a listing into registered status in Matrix. To begin, visit go.crmls.org and click the login button. You can also access CRMLS through ocrealtors.org in the top right toolbar. Enter your user ID and password, then click Login. Your RE Core dashboard will display as the home page. Select Registered Listings from the left side of your RE Core dashboard. A registered listing means the listing is entered, but it isn't active on the MLS yet. Registered listings will not appear in the MLS, nor will they be distributed anywhere. There are 4 tabs you'll need to complete: Location, Listing Info, List or Co-List Agent, and Confirmation. First, complete the Location tab. Fill in all required fields marked with an asterisk. Start by entering the property address in the Search for Listing field. You can select the address from the list or manually enter the street address, city, state, and postal code. Click Next to continue. Next, complete the Listing Info tab. Use the drop-down menu to select the property type, such as residential, land, residential income, or residential lease. Enter the list price, listing contract date, and expiration date. If applicable, enter the start marketing date. Then click Next to proceed. Please note, listings excluded from the MLS will not have a start marketing date. Be sure to check the appropriate box to confirm the property should not be publicly marketed and is compliant with MLS rules. Now, complete the List or Co-List Agent tab. Enter the required List Agent MLS ID or select one from the drop-down menu. If applicable, enter the Co-List Agent MLS ID. Click Confirm to continue. If you need to review or update any information, you can return to previous tabs at any time. If there are errors, a pop-up message will appear in the top right corner, prompting you to correct them before moving forward. Finally, review the information on the Confirmation tab and click Save. A pop-up message will appear in the top left corner, displaying your new registered listing ID. This confirms that your registered listing has been successfully created. To send a registered listing to the MLS, select the green arrow button under Actions. A pop-up message will appear to confirm. Click the Send to MLS button to complete the process.
You pause it.
Note:
So why would we register a listing? Anybody want to tell me?
To protect yourself.
Good answer. So you take a listing and the beginning date of the listing is today, but you're not going to be in marketing it till some future date. So within the multiple listing service addendum, you're going to have a start marketing date that's different than the beginning date. So if you have a start marketing date that's different than the beginning date, you have an obligation to register that listing within 2 days of the beginning date of that listing. If not, I think it's a $1,500 fine. So if the start mark, pardon me?
New, right?
What?
That's new.
No,
You've always had to register?
2 years ago. Yeah, yes.
I'm guilty.
If the beginning date, if the beginning date is today, and then you're not gonna put it into MLS or active in the MLS for 2 weeks from now or a later date, that's when it has to be registered.
But I thought that's what a CLM was.
The coming soon form,
Yeah.
that's different. It'll show up in the MLS as coming soon for people to see, but you can't show it. This one, nobody sees in the MLS, but the MLS knows you have the listing.
But you can actually show it when it's registered. You can show a registered property. You can't show a property that's in coming soon status.
No, I mean, shows up in the MLS for agents to see it.
Right, it does not show up in the MLS, correct. So remember the SELM form, it's in a sense, it's still available, but it's been replaced because in the listing agreement, the form MLSA is below this, it's in there and it addresses the start marketing date. So you don't have to use a separate SELM or sort exclusion from listing.
You check the box and you add in your date.
Yes, the start marketing date, exactly. So if it's different than the beginning date, the line 3 in the listing contract, you're going to register that listing.
Okay, so even if you do that, then you still have to register.
Yes, you still have, if you're right, if you're not going to begin to market it, if it's not going to be an MLS, based upon the beginning date of that listing agreement, you must register it. And then once it's registered, once it's going to be going active, that's going to be the next video. We want to then convert a registered listing to an active listing. So if you'd continue.
Once Send to MLS is clicked, this process cannot be halted or canceled. You will receive a confirmation message that will indicate your registered listing has been sent. To complete or publish the listing, navigate to My Incomplete Listings under the My Matrix or Add Edit tabs.
Excellent here.
It's editing and managing registered listing.
Okay, great. Yes.
You on how to edit, send to MLS, or cancel a listing in registered status. To begin, select Registered Listings from the left side of your Record dashboard. From here, you'll see 3 available actions: edit, send to MLS, or cancel. To edit a registered listing, click the blue pencil icon under the Actions column. Update any outdated or incorrect information, then click Save to proceed. A confirmation message will appear once the update is complete. This will create an incomplete listing under the Add Edit tab in Matrix. To send, click the green arrow icon. Once a listing is sent, this action cannot be reversed or canceled. Review the confirmation pop-up, then click Send to MLS to complete the process. A pop-up message will appear to confirm that the listing has been sent. There may be a 20 to 30 minute processing window while the listing information is sent to the MLS. During this time, the listing will appear as processing in your dashboard. To cancel a registered listing, click the red No symbol under the Actions column. Enter the cancel date, then select Cancel Listing to remove it.
Self-explanatory, right? Just convert it to an actual listing. And then the MLS listing ID will be assigned. What's the next one?
The CRMLS citation.
CRMLS citation. All right. Pause that. So the reason we wanted to show this, it's possible you may receive notification of a violation for whatever reason. And of course, how do those come about? It's because your peers are reporting you. That's what's going on. And they can report you anonymously. So then once it's reported, then the CRMLS, they'll investigate it. They may ask you for documentation. And if they find you in violation, they're going to issue a fine typically. So with that fine, you can actually contest it. And you can do that in front of a hearing panel, but it's going to cost you an additional $200. Or you can just actually, the second choice is to contest it. It can go in front of a committee. So just recently, I had 8 different appeals, which people were contesting the fines. And in virtually every single case, they're saying, please forgive me. I didn't mean to do it, or I made a mistake. So there wasn't one of those cases that was appealed that we said, okay, we forgive you. So don't waste your money. Maria, I see that look in his face. No,
They had to pay a fine.
they have to pay the fine plus an additional $100. If you have a full committee hearing, it's an additional $200 in addition to the fine.
So your fellow agents that report you don't even make anything.
They don't make anything off of it. Correct.
Bunch of haters.
Very
What?
Yeah, but there's a lot of people out there doing things they're not supposed to be doing,
Mhm.
making you look bad, and just other villagers look bad.
So if they said, hey, it was just a mistake, that doesn't fly. They actually have to show evidence that it did not happen.
Yes, yes. Otherwise, I've never been on a panel in which we have forgiven, and if there's actual hearing, CRMLS also sends somebody to represent CRMLS. And what do they say in every single case? We want the fine upheld. They never once have said, oh, why don't you reduce it by 50%? Oh, they're a good person.
Don't waste your money. Don't appeal it. Just
Yeah, that's, unless we think there's a real reason, don't piss your time away or your money away.
You just hear Rich like laughing. Rich is laughing in the background. Someone loses their.
I wanted you to be aware, and then I think there's one other video we're gonna play. If you have 4 violations in 1 year, then you're going to be brought in front of a hearing panel with me. Unfortunately, we're both going to be at risk for whatever the punishment. Now, I haven't had to attend a committee meeting like that in the past, but it's possible.
January 1st, 2021 for any MLS rule violation that would result in a 4th citation in any calendar year. The agent and office manager or broker shall appear before a professional standards hearing panel to adjudicate the alleged MLS rule violation and determine additional sanctions the panel deems appropriate for the subscriber's continuing failure to follow the rules, and determine sanctions the panel deems appropriate for the office manager or broker's failure to properly supervise and correct the subscriber's continuing failure to follow the MLS rules. To avoid CRMLS citations or violations, please visit our website at www.ocrealtors.org or call the MLS department at 949-586-6800, extension 700.
Violations and Rich is getting rid of it.
I just hate to see people getting fines for things that aren't necessary. So if you're going to advertise a property and you put your sign up, be sure within 1 day of putting that sign up that you now have it on the MLS. If you're saying it's coming soon, you don't have a coming soon form that's signed concurrently with the listing contract, then you're in violation and you put in a coming soon status. So if it's registered, that's fine. Just don't show the property. Don't market the property. You can actually show the property in registered status. You cannot show the property in a coming soon status.
And if you have a coming soon listing and you have a sign out, you should have coming soon and the date it becomes available on the sign.
That's correct. So the date it's going to be actively marketed should be on that coming soon sign. So it's very easy to report all these different violations, and I think CRMLS, they budget for receiving about $500,000 a year in fines. So that's part of their revenue stream. Now they have 8 analysts that they pay. So I don't know if it covers everybody, but that is how much the fines consist of annually in their budgeting process. It's a revenue stream. Did we hit all the topics then? Copying and listing, we want to do that, right?
This quick overview on using the Copy My Listing feature in Matrix. Before you begin, there are a few important things to note. Agents can only copy listings if they are with the same brokerage as when the listing was originally entered. Office brokers may copy any listing that originated from their office. The listing must also be in the same category. For example, a previous lease listing can only be copied to create another lease listing, not a residential sale listing. When copying a listing, most of the original data will transfer automatically. Be sure to review all required fields and update key details such as the list price and contract start and end dates. To get started, have the MLS listing number you want to copy ready. Next, click on the Add Edit tab and select Add New. Under Select Form, choose the appropriate property type. For this example, we selected residential. Click Copy My Listing. Enter the listing number and select Fill From. Once the information is populated, you can either submit the listing or save it as incomplete to finish later. Important note: photos do not automatically transfer when you copy a listing and must be uploaded separately. When you see the Input Succeeded screen, the listing has been successfully saved as incomplete and assigned a new listing number. Continue by selecting Add Edit Photos. Select the Click Here to import photos from another listing link. Enter the original listing number in the MLS error field, then select Import Photos. Arrange the photo order, add descriptions, and then select Certify and Save. Your listing is ready for the next step.
So I had one case, at least, where somebody copied the listing and there was incorrect information or something that was resulted in a violation, and they didn't reread the listing after they copied it. So once again, they were fined and it was upheld. And then the photos, remember, don't copy them from the MLS because they're watermarked. With MLS on it, you cannot reuse those watermarked photos.
But they just said you can use them by copying.
They said don't.
I thought there was
I
a
thought they
link
said don't.
at the end.
The original photos.
Yeah, right here, they show you how to
Say don't.
You had, if they were your photos.
from another list. Yeah, look, you can copy the photos from another list.
Yeah.
I didn't even know this was an option.
To import photos from another listing. Well, I wouldn't do that.
Maybe if one that expired and then you're redoing it.
Well, from your previous listing.
I understand what you're getting at. I thought I heard something different, but ideally you have the original photos. Any questions about that? No? All right. Well, that concludes today's presentation, everybody, and thank you for coming. Let's avoid some fines now. That's good news.
So as long as I put the listing in within 2 business days, I don't have to register it.
2 days.
2 days. Two regular days.
No, I'm sorry, I didn't mean to interrupt.
2
Yep.
calendar days within signing the agreement.
Yes. So if it's not going to be marketed until the future, you need to register within 2 days of that listing agreement being act or valid.
But if I'm going to put it up as active within 2 days, I don't have to register.
Correct. Just remember, the beginning date is actually the date that it was of the last signature, not 2 days later when you put the listing contract in. Start date is equal to the date of the last signature, excluding the listing agent signature.
Jeff is asking about the coming soon form.
Yes, there's instructions to coming soon, Jeff. So it's in the library, and you would have that signed concurrently with the listing agreement. And coming soon is just a status, it's an active status, but the days actively marketed do not count. And remember, it can only be in coming soon status for 21 days. And if you remove it from coming soon status during that 21 days, you can never go back to coming soon status. So yes, there's a coming soon document that you would use when having a listing contract signed. I think he would answer, but he doesn't have a microphone.
No, you would have typed something in.
Okay. Does that help, Jeff? Does the answer, Jeff?
Good.
a number of people.
There it is.
Yes, okay, great. Great.
Thank you.
All right, thanks.
Thank you.
Thanks for coming, everybody. I appreciate it.